This is INEC's final report, INEC's final written address, and it's stated clearly in there on page 13. It's a 41-page document that Dr. Lawrence Bayode, who happens to be a deputy director with INEC, an assistant director with INEC, made statement on oath. Statement on oath. Now, when statements are made on oath, if they are false, then it is perjury. That's how serious statements on oath are. Now, look at the statement that he made. He stated there that there was no collation system of the first respondent, which is INEC, to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer. This is false. This statement is false. There is a collation system in place that requires the polling unit officer to transmit the results electronically from polling units to the registration area. There is a system in place. Even INEC themselves explained this system. Another false statement that INEC made in their final written address is this. They claimed that the first respondent case is that collation of the election result remained a manual process. The failure to transfer the result sheets of the polling units in the presidential election using the BVAS device was because of a technical glitch on the first respondent, that's INEC now, IREV application. And this did not in any way affect the collation process or the results declared. Now, this is obviously also false, because from what INEC will explain themselves, I'll play you the video shortly and show you the subsequent section in the Electoral Act and also in INEC's guideline. From what we will see shortly, you will see that INEC in their final written address, which I am sure was written by senior advocates, outrightly told a lie, and it was done under oath. So this is perjury again by INEC. We have seen cases of perjury by Tinubu and APC, but right now this is perjury by INEC. Please watch and see for yourselves how INEC contradicts themselves in their final written address compared to what they said before the election, and also compared to the provisions of the Electoral Act and also INEC's own electoral guideline.
Are people still going to be able to view those results as they uploaded on INEC portal?
Yes, of course. It's real time. From the polling unit is straight to the IREF. And if there are any issue, by the time the presiding officer gets to the collation center, it tenders the BVAS to the collation officer. It tenders the hard copy of that to the collation officer. The collation officer is looking at the physical result and the one that was already transmitted to the IREF. Just oppose these two and see if there's any discrepancy, checking whether what is seen on the IREF is the same thing that is before him physically. So if everything went well, then the collation officer go ahead to enter into his own form at that level, the form EC8B at that level.
And that form will also still be displayed?
No, we are not transmitting that form. We are only transmitting form EC8A.
Yeah, that EC8A.
Yes.
Much as they will snap it and upload it, they will still display it as required, isn't it?
Yes, it will still be displayed at the polling unit. That's the form 60E at the polling unit. It will be displayed there. But the result itself will be taken to the collation officer and the BVAS. The collation officer checks the accredited data, checks the form EC80, that's the result sheet, and also check the one on the portal to see if there are any discrepancy, whether they are the same.
Result as handed over to him, he or she will also look at the BVAS as handed over, and then look at the from EC8 or the polling unit level result as already transmitted through the IREV, and the accreditation data as already transmitted before entering the scores into from EC8B, which is the registration area result. Now, if there's a dispute, relating to the physically transmitted result, so to say, and the electronically transmitted result. By our own regulations and by our own guidelines and procedures, the electronically transmitted data and the electronically transmitted result will take precedence.
The electronically transmitted data or the electronically transmitted result would take precedence. What is the electronic transmitted result? That is the IREV result. So this is the INEC commissioner stating clearly what is actually also clearly spelled out in the INEC guidelines, which he also referenced, and also in the Electoral Act, which he also referenced. So it is not just that it is backed by the INEC's guideline or backed by the Electoral Act 2022. We had INEC commissioner and the director of ICT confirming this same position before the election. And then we now have INEC put in their final written submission at the tribunal, and they make a 180 degrees U-turn to state under oath that this is no longer the case. This is perjury. So aside from even bothering about the result of the election, which I am sure that the justices or the presiding judges know what to do, this is perjury, and these persons who have made these statements, the senior advocate that made this written statement, the INEC officials that made these statements should be charged with perjury. The court must not continue to allow these kind of things to happen. If not, it will be bringing the reputation of the judiciary into disrepute and dragging them in the mud. They must not be allowed to go scot-free with perjury.
The Commission will also transmit polling unit level results in real time. The transmission of polling unit level results is also a mandatory provision of the law, as Section 64, subsection 4 of the Electoral Act has made it mandatory. The Commission will also transmit polling unit level results in real time. The transmission of polling unit level results is also a mandatory provision of the law, as Section 64, subsection 4 of the Electoral Act has made it mandatory.
How fail-proof is it as far as hackers are concerned, or hacking for that matter? Do you have any concerns?
We don't have any concern, because we have tried our best to ensure that the system is secured. The data on the system is secured, because we're transmitting data from this device to our backend. The data in transit is also secured. And by the time this data is getting to our backend, we have ensured that this data at our backend will also be secured.
This informed the early choice of a new voter accreditation technology using an electronic device called the Bimodal voter accreditation system. We have tested it in several by-elections and off-cycle governorship elections. In addition, the decision to make polling unit election results available for public viewing, which has always been a major demand by citizens and election observers, falls into this early choice of election technology. The INEC Results Viewing Portal, the IREV, is a dedicated web portal for the public view of polling unit results as soon as they are finalized on election day.
There seems to be so much perjury going on right now at the Election Petitions Tribunal. From APC to Tinubu to INEC, from witness to even now SANs, senior advocates. Perjury is on rampage. I would expect that these people understood what perjury is, and perjury is supposed to be a very, very serious offense, because you can say anything with your mouth, but when it comes to saying it under oath, it is a serious matter, and people usually take it seriously. Perjury is even more, it's worse than even contempt of court, because it appears to target the same effect on the court. Make nonsense of the court, make nonsense of the judges, make nonsense of the judiciary. That's the whole intent of perjury. and for perjury to be on rampage from INEC to APC in their final written submissions, for perjury to be on rampage from witness to even senior advocates, then we have a problem. I hope the judiciary is taking note, because if the judiciary allows this to slide, it will be a slap on the face of the judiciary. What is perjury? Is it that these people, these senior advocates, have forgotten what perjury is? Is it that these witnesses were not told what perjury is? Saying something under oath, whether you swear by the Bible or you swear by the Quran, is a very strong thing in law. So whether the witness refused to swear by the Bible, like the pastor, the deputy director at INEC refused to swear by the Bible for whatever reason, even though he's a pastor and a Christian, does not disregard or does not mean that whatever he said is not under oath. It is under oath. In their written submission, the senior advocates actually made submissions that were purely false and would seem to either be threatening the judges or ridicule them. Because when you make statements that are outrightly false, then you are trying to play on the intelligence of the judges or the justices. The judiciary must rise up to this. The INEC witness, the pastor, came on national TV alongside Festus Okoye to claim, or not to claim now, to state categorically that election results will be transmitted live, will be transmitted real time. And the INEC Commissioner Festus Okoye corroborated this fact. These are evident on video on national TV. And this is in line with black and white statements of the Electoral Act of the INEC guidelines on the same 2023 elections, that the transmission of election results will be the transmission of election results will be transmitted live, and that the results will be displayed on IREV. In fact, they explained clearly that at the registration area, which is the World Collation Center, the results will go from the polling unit to the World Collation Center. INEC Commissioner Festus Okoye, with the Deputy Director in charge of IT, explained clearly to Nigerians, and this is on video, it's on tape, and it is in line with the INEC guidelines on election and in line with the Electoral Act 2022, that for results to be collated at the registration area at the ward level, the INEC collation officer will cite the physical copy of the polling unit returning officer and then compare it with the IREV version. And if there's any discrepancy, the IREV version would take precedence. This was what INEC said with their own mouth, with their own guideline, in consonance with the Electoral Act and of course with the Constitution. But then when the same witness comes to give witness in court for INEC, the same pastor, he comes and says the exact opposite. The same thing happened for the witness of Tinubu and APC, the senator. What is apparently clear concerning the Tinubu case at the Tribunal, the Tinubu US drugs related case? What is clear? That there was a conviction, there was a charge number, there were 2 charges slammed against him, and there was a sentence of fine. It's clear, all in black and white. The same senator came and told the court under oath that there was no charge number, that there was no conviction, that there was no sentence or fine. Blatant lies. I don't know if this is a display of impunity or if it is an action that is intended to spite the judges and indeed spite the judiciary. But these are clear perjuries. Now, if it ended with the witnesses, then one would say, oh, perhaps they didn't know. Or maybe because they are junior lawyers. Because the senator who stood as witness for Tinubu is actually a lawyer. He claims to have license to practice law legally, nationally, in the US. So let's even assume that they are just witnesses. They didn't know. What about the senior advocates that put in the final written request, the written submission for INEC and for Tinubu? They came and were making claims that were outrightly false and representing them as true. The one of INEC is the one that is even most outstanding, most annoying. If it is annoying to me as an ordinary Nigerian, how annoying should it be to the presiding judges? How annoying should it be to the judiciary? Now, I don't know what gives them the confidence to carry out such impunity in the face of Nigerians, in the face of the judiciary. I don't know if they feel that they have the judiciary in their pockets. I don't know if they have a reason to be so bold as to threaten the judiciary so clearly that if the judiciary rules and disqualifies Tinubu, then it may lead to anarchy. I don't know what's giving them that confidence, but it is up to the judiciary to look at these clear violations, to let people know, to let Nigerians know, to set the record straight so that these people that have come out to carry out blatant perjuries will be called to order. It is up to the judiciary. It is up to you, the justices. It is up to you. Because if you continue to allow these things to go on, more people will come and be perjuring themselves before the court because they would think that nothing will happen to them. Oh, judges, these must not be allowed to slide. Witness statement in court should be taken with grave seriousness, not just from the witnesses, but even from the lawyers. And the NBA should take a cue from this, not just the judiciary now, and call the lawyers, push them to the, not even NJC now. They must appear before the Legal Practitioner Disciplinary Committee. They must appear. They must be dealt with, because it pulls down the whole tenet of justice. It impugns upon the integrity of the judiciary, and it makes nonsense of the whole judicial process. If nothing is done to these people, if they are not punished to serve as a deterrent, others will follow and come and be making false statements under oath. False statements under oath, because they see that if they see that they can do it and get away with it. So the judiciary must stand up, if not for anything, must begin to file perjury charges against these lawyers, senior advocates or not, these witnesses that are making false statements, statements that are blatantly false under oath, in the interest of the continued coexistence of Nigeria and the interest of justice in Nigeria. O judiciary, O justices, the ball is in your court. Nigerians are watching. When you serve justice, Nigerians will see, and Nigerians will clap for you.